Hi gang, it's Alan Stewart with your Real Estate 101 tips and tricks for the week of July 30th, 2014. There seems to be some confusion out there surrounding the idea of a material latent defect. What kind of defect constitutes a material latent defect, and what's a defect that a buyer needs to go and uncover on their own if it's important to them? There's a clear definition of material latent defects at the bottom of the property condition disclosure statement, and it states pretty clearly that there's 4 different types of defects that need to be disclosed by a seller to a buyer prior to them entering into a contract. The first category would be one which renders the property either dangerous or unfit for habitation, or renders the property unfit for the purposes for which the buyer is purchasing it. Now, those purposes would have to be disclosed to a licensee, but that sums up the first category of material latent defects. The second kind of defect is one which would cost great remedy to repair. So that's a defect, structural defect, anything that's going to cost a lot of money to a buyer. It's incumbent on the seller to tell a buyer about that, regardless of whether or not it's something that they should easily be able to determine through a building inspection. The third kind of a material latent defect is one in which we've received notice from a public body about a defect on the property. So for example, if the town you live in has given you notice that there's Japanese knotweed on your property, even though the Japanese knotweed is 4 feet high in the backyard, and any buyer or buyer's agent or inspector should be able to determine that, because we've received notice from a public body about the defect, it's incumbent on the seller to disclose that information to the buyer. And finally, the fourth category of material latent defect that needs to be disclosed would be lack of a municipal building permit for work done on the property. There's no easy way for a buyer to ascertain that, so it's incumbent on the seller, again, to notify the buyer that we've done some work without a permit. Don't forget that our recommendation to all buyers is they get an independent inspection done of their property, all elements of the property, to protect themselves, because caveat emptor still applies in the province of British Columbia. It's not up to the seller to disclose every defect to the buyer, only those defects which the courts would consider to be material latent defects. From time to time, we'll come across a situation where either the buyer or the seller or both parties will want to keep the terms of a contract absolutely confidential. They won't want the contract used against them in a way that might be disadvantageous. You'll find in web forms a seldomly used clause called the Confidentiality of Terms Clause, and you can go ahead and incorporate that into your contract of purchase and sale in order to bind both parties to the fact that they can't share the information contained within a contract in order to put them at an advantage. So that's the Confidentiality of Terms Clause. You'll find it in web forms, and from time to time you'll find it very helpful. One of the most common problems we find when reviewing contracts of purchase and sale, and it's probably on 60% of the deals that we review, is that the seller has failed to tick off whether or not they're a resident of Canada for income tax purposes. Now, why would you want to make sure that this is ticked off for either a buyer or a seller's agent? Because you want to avoid problems at closing. And if this hasn't been addressed and it turns out that the seller is not a resident of Canada for income tax purposes, guess what? They're going to have to hold back this money from the completion funds, and it's going to cause a hiccup. And we don't like hiccups. So do yourself a favor, either before or after the deal has been consummated, make sure that before that information goes to the conveyancers, you have the seller tick off whether or not they're a resident of Canada. You'll find it right in that box, in the information box about the seller with their address. They need to tick off whether or not they're a resident of Canada for income tax purposes. On pre-sale condos, there's often a commission advance offered to the buyer's agent, wherein they'll give you half of the commission up front before your buyer even completes on the transaction. However, there's often in the hard wording of these agreements a section that states the brokerage will be responsible for repaying any commissions in the event that the buyer fails to complete. This is obviously problematic because we don't have the money anymore, you do. And if you have the money, it's you that should be responsible for repaying it. So if you want to get your commission advance taken care of, just go and see Wendy or Denise in conveyance or Eileen up on the Sunshine Coast and ask for what's called a commission advance waiver form, wherein we've put together a simple form that states it's not the brokerage that's responsible. If you want to get your money back, Mr. Developer, you'll need to go and chase the licensee. It's a fair and reasonable form that eliminates the risk for the brokerage and enables us to help you get your commissions well in advance of completion. But you always need to remember, if the buyer doesn't show up to complete, you're going to have to pay the money back. When is a strata property not a strata property? All strata corporations are responsible to comply with the Strata Properties Act. However, from time to time we'll come across situations wherein a half duplex or a bare land strata are not complying with the requirements of the Act. So what do we do if we're representing a buyer and we're faced with that situation? Well, it's relatively straightforward, fortunately. Essentially, you want to make sure that your buyer seeks independent legal advice as to the risks involved in purchasing into such a strata corporation. And once they're comfortable with the idea of moving forward with the purchase, simply have them acknowledge the fact that the strata corporation corporation is not being run in compliance with the Strata Property Act. I'll include some wording below in the YouTube video that you can use and copy and paste into your contracts of purchase and sale, but be sure to have the buyer acknowledge the fact that they're aware the strata property is not being managed in compliance with the Strata Property Act, and everything should be just fine for you. Let's talk about a situation that's happening more and more frequently and that's really frustrating, particularly for our realtors up on the Sunshine Coast and Squamish, when we have what we refer to as parachute realtors coming in and failing to be present for their showings with their buyers. We're also seeing this in Vancouver, wherein people are calling a half an hour before a showing and asking the listing agent if they'll go ahead and show their clients through the property because something else has come up and they're not able to attend the showing. Now, this puts the listing agent in a really awkward situation. Why? Because it's their job to sell the house. They want to go ahead and do everything they can on behalf of their sellers to make sure that a transaction takes place. So why wouldn't they just go and do the buyer's agent's job? Well, there's a whole bunch of things for us to talk about. Let's talk first about buyer's agents. If you're a buyer's agent and you're expecting someone else to do your job for you, in effect sell the property, don't be surprised if there's a claim on commissions as a result. The Arbitration Committee for the Real Estate Board of Greater Vancouver makes its decisions on the following. Who was the effective cause of sale? And guess what? If your clients show up at a house and they like that listing agent, they want to go ahead and write an offer with them, and you don't have an exclusive buyer's agency agreement, even if you have a working with a realtor brochure signed with them, if you aren't the person responsible for the sale, if you're not the effective cause of sale, there's a very good chance you could be out your commission. And it's going to be hard for your brokerage or anyone else to support you in the argument if you weren't even present at the showing. So I really encourage you, if you're a buyer's agent, don't fail to show up for showings. Don't expect the listing agent to do one of your very primary responsibilities in showing properties to clients and making sure they understand the value inherent in them. For the seller's agent, I would encourage you to have an open and frank conversation with your sellers about a whole bunch of things. Number one, talk about it in the beginning. Let them know that this is a practice that happens from time to time where realtors working with buyers may fail to show up with them or want us to handle their showings for them, and look to them for their instructions. But I wouldn't discourage you from having a conversation with them around the fact that it's important to have a buyer's agent present. If you're looking for a good argument for your sellers as to why to restrict showings to only buyers who are represented there with their buyer's agent, you could talk about the problems at closing when a buyer's agent hasn't been present. Which situation do you think is going to cause more problems at closing? A situation wherein a buyer has had a quick look through the house with the listing agent, or a situation wherein the buyer's agent has gone through the house in advance with a knowledgeable licensed realtor prior to having a building inspection done? Why a buyer's agent could find defects that may be important to the buyer and which may eliminate them from being part of the conversation after the inspection is done, and thereby opening up the contract and having to renegotiate the price. How about things like Japanese knotweed that maybe the buyer's agent would find on the property, but maybe the seller's agent doesn't really want to disclose? How about things like potential asbestos in the home that a buyer's agent could easily recognize, wherein a buyer without any knowledge would have no idea? Those things can be addressed before the negotiations when everybody's aware of them, rather than afterwards, after having a building inspection and then having a buyer come back looking for a significant price reduction as a result. So I think it's best for everybody to have both realtors present for a showing. At the very least, have the buyer's representative present with the buyer so that they can help recognize and point out to buyers all those things that are important for them to know in their buying decision, rather than having to renegotiate and open up the contract after the fact. And if you can have a conversation with your seller beforehand and get their instructions to refuse any showings that whereby the buyer's agent isn't present, it takes a lot of the animosity out of the equation. You can simply tell the buyer's agent that, I'm sorry, but we can't facilitate showings without a buyer's agent being present. That is my seller's instructions. We talked a little bit about when a strata property is not a strata property. Let's talk a little bit about when a material latent defect is or isn't a material latent defect, and who makes that determination. One of the things that constitutes a material latent defect is when you receive notice from a public body about a particular situation. That would be something that you would have to disclose, a defect you would have to disclose to a buyer. Let's talk about a situation that occurred recently up on the Sunshine Coast. Pender Harbour had an ongoing situation with its foreshore licenses for years as a result of negotiations ongoing between the Seashell Indian Band and the Integrated Land Management Bureau. And traditionally, what's happened is that the Integrated Land Management Bureau renews leases. They're not accepting new applications for foreshore licenses, but they've always renewed the leases, and so that's been the expectation of the clients. However, the lease is pretty clear. It doesn't automatically state that the lease will be renewed. So when a buyer reads through that lease and assumes that the lease is going to be renewed, is it the seller's responsibility to disclose the fact that they know the lease won't be renewed? Well, I've consulted with a number of lawyers as well as the Real Estate Council of British Columbia, and they all recommend that both parties need to seek independent legal advice. If it is a material latent defect, then it's the responsibility of the seller to disclose. Is it a material latent defect? I have no idea. All the terms and conditions would be easily readable in the lease, and nowhere in there does it state that the lease will automatically be renewed. And so if that's the case, does the seller have to discount the value of their property because their lease may be up in a few months or a few years and the buyer may or may not be able to renew it? Or is it the responsibility of the buyer to go ahead and make inquiries if that's important to them? There's probably an argument to be had on both sides of the equation. Anytime you're dealing with a lease, it's really important that the buyer and the seller both get advice if they're aware of a situation that's going to affect the lease moving forward. I've always said, when in doubt, disclose. But disclosing this information may have a significant bearing on the value of the property, and so it's important to go and seek some independent legal advice. And I know that's a bit of a bummer of an answer. Nobody wants to hear it, but it's the truth. It's a complicated situation that needs expert advice. Did you know that the BC government has imposed new legislation requiring builders to disclose the tax status of a property before selling a new home? Just last week we had a situation wherein one of our agents represented a buyer in a $2 million new home purchase. They included the GST in the purchase price, however nobody addressed the transitional tax. On a $2 million home, that 2% equated to over $40,000 that the buyer was going to have to be responsible for at closing. And guess who's not very happy? Whenever you're representing either a buyer or a seller, it's critical that you include a new form that's available to you in web forms. It's called the Contract of Purchase and Sale of a New Home Addendum, and in it, it clearly lays out the tax implications of purchasing that home. It addresses the GST, it also addresses the transitional tax that's applicable up until the end of April of 2015. So, and any contracts put together between December 1st of 2012 and March 1st of 2015, it's the responsibility of the seller to have made a disclosure to the buyer as to the tax implications of purchasing that home. It's the responsibility of the seller to provide it. Penalties can range from $10,000 to $40,000 for not providing this disclosure of the tax status. Make sure you get that for your buyers and get that for your sellers to avoid all kinds of problems at closing. If you have any questions about the information that we've shown you here today, be sure to call me at 604-990-6397. I'll do my very best to answer any questions you might have. And if you have any questions that you'd like me to address in upcoming episodes, please don't hesitate to send me a line. You can always reach me at alanstewart@prudentialsussex.com. And remember, nothing succeeds like Sussex.